What's the next move? Does Trans Mountain have to go through the full metal jacket again, a full inquiry, or can they truncate it in some way?
No, I think the court only requires them to go through, to revisit the parts that the court pointed to, which is the tanker traffic issue and the First Nations consultation. So they can limit it just to that, to those two issues. Now, how long does that take to do that? Especially the second one, a proper First Nations consultation, that's anyone's guess, but those don't tend to usually be short.
Now, I don't want to politicize this. I mean, two governments have tried to get this project through. They've run into roadblocks. But the environmental approval process that was faulted by the Federal Court of Appeal, was that Stephen Harper's streamlined process?
So what the Harper government did, I think in 2012, was they consolidated and they made them the National Energy Board became the regulator under both the Environmental Assessment Act and the National Energy Board Act. So they were doing two review processes by one panel. So it's the environmental piece which was criticized, although not overturned by the court. It's interesting. They faulted it and they said it was lacking because they failed to review the environmental impact on the killer whales of what would happen in the harbor. But the applicants, part of the application was to overturn the NEB's decision, and the court declined to overturn the NEB's decision. What the court did is overturn the cabinet's decision.
Right. Yeah, so we shouldn't say the NEB approval was overturned. It was criticized, I think it's fair to say.
I think they said it was significantly flawed, and yet they didn't overturn it. Interesting.
Right, but of course it gets strange here because the NEB said, well, look, it's not our job to assess the impact on marine mammals.
That's right. The board said, actually, it's quite interesting. The board said that there are a number of other agencies and regulators who regulate what goes on in the waterways and marine traffic, and so that's not our position on the environmental piece. But they did say on the NEB Act piece, which is the board's other mandate, the other hat it wears is to assess the public interest of the project, they did say that they would review the marine traffic under that guise. And they, in fact, spent 80 pages in their decision talking just about the marine tanker traffic issue. And yet, so the court said, well, the board erred, essentially, it was flawed by not considering the marine traffic in the environmental assessment. And it's true, they didn't. They said this is not part of our environmental assessment. But they spent 80 pages discussing it on the other part of their report.
And did they come up with a conclusion in that other part of the report as to say the risks are justified, for example?
I think what they found, what they said was they can be mitigated. So that was part of the hundreds of conditions they imposed were the mitigation factors.
Is this a historic ruling by the Federal Court of Appeal, or is it just another episode?
I think it's remarkable in a couple of instances. The first one is on the First Nations side. So obviously, it's routine to have First Nations challenge and say our consultation wasn't done properly. But here, the Court of Appeal really sided with the First Nations for not the first time, but it goes as strong as to say that the consultation is not just talking to people. You actually have to react. It's a two-way thing, not a one-way thing, not just a listening.
And I think they said Ottawa did not listen, did not take the input from the First Nations on board, sorry.
They essentially said you listened to them, but you didn't do anything with it.
Right.
You can't just take information and then stick it in a file. You actually have to react and make changes to the project to accommodate the concerns that are being raised. So that was the first piece. The second interesting factor was that the court overturned a cabinet decision. As far as I can recall, that's fairly unique. This is not legislation that's been challenged and overturned. This is a cabinet vote inside a cabinet room, which has been overturned by a court of appeal. I don't know any other instance where I recall that happening. So that's fairly unique as well.
And that's the thing Mr. Harper brought in, wasn't it? That the cabinet had the final say after the NEB made a ruling on whether to approve a thing or not.
That's right.
And the Liberals kept it.
Yes. In fact, went further to say that the cabinet will have an even greater role. Even after the NEB finishes making its recommendations, Justin Trudeau said we're going to go further and have the cabinet do additional First Nations consultations. That's
interesting. So the courts, they must have weighed this very carefully. It has some constitutional implications, said, nope, a cabinet decision was flawed.
Yeah, I would imagine. I'm no constitutional expert, but just as someone who's studied politics, to have a court interfere with a cabinet decision is definitely interesting.
Is there a way to accelerate this thing, these consultations and the consideration of the effect on marine mammals?
I don't think it's a question of accelerating. Doing it faster doesn't save the killer whales or doesn't address the First Nations needs and concerns. It's a question of can you actually build these projects in Canada and meet all the requirements that all the interested parties bring forth.
Have we come to that stage where we have such an unwieldy system or a system that takes so many factors into account, it's a real roadblock now to big projects?
Definitely. I mean, like the Court of Appeal decision here has basically said that when you're looking at a pipeline, you now also have to look at what happens to the oil after it leaves the pipeline. That's another unique factor here. Up until now, the decision's been the NEB's role is to look at the pipeline itself. But the court said, well, you got to look at the tanker traffic, which is what happens after. Now, if you're going to take it that far, well, what happens after at the end of any pipeline? Where is the oil used, and what manufacturing process is it used in? Do we have to look at that as well? Do we have to look at the carbon emissions by the purchaser of it? Is it going to, to provide something, money or energy to terrorists? I mean, you could take this as far as you can go.
Because the NEB traditionally said, look, we can't look at climate change. That's a thing that belongs to broad government policy. But of course, Mr. Trudeau has thrown that out and says, no, you have to include global warming.
Well, it's not even that it wouldn't even go that far. The NEB said we will look at climate change from the beginning of the pipeline to the end of the pipeline.
Okay.
We just won't look at it before it gets onto the pipe or after, because we only regulate the pipeline. The Court of Appeal has said, no, you made a mistake by not looking at what happens after the oil leaves the pipeline.
Yeah, I mean, I suppose we shouldn't say that America is the land of milk and honey for energy approvals. I mean, things get politicized down there, and just a week or so ago, a Maine town managed to block a plan to have a pipeline run through it that would have exported oil sands oil. So does Canada stand out in our system being so cumbersome?
No, I think, in my view, anything related to energy is politicized wherever you go. The difference here is that oil and gas in particular plays such a key role in Canada's economy that when it happens, it reverberates much more broadly than in other places.
So what can Mr. Trudeau do? I mean, what a thorny one for him.
Yeah, I'm not sure, to be honest with you. I mean, they obviously have the legal right to appeal to the Supreme Court of Canada. I would be surprised or interested to see if he's able to do that politically.
Over the decades, have we just had an approval system that became more and more complex? Is that the problem? Or because these things used to just get nodded through, didn't they, in the old days? We didn't report on pipeline approvals much.
Yeah, I don't think it became more complex. I think people started taking more of an interest and becoming more active. I think social media and other technology and communications venues have allowed that to happen. And frankly, people have become more activist. And so people are aware of what's going on. They're much more aware, and they're taking part more and more. I don't think the process has changed, but the participation in that process has changed. And that's probably the problem. The process hasn't changed, even though the participants have.
Yeah, the Enviros got smart, I suppose. They see these pipelines as a pressure point, a jiu-jitsu point that you aim for, and they can block the oil and gas.
Yeah, no, absolutely they have. And the First Nations have established their rights, which weren't properly established before. They have legal and constitutional rights. So that's all new, but the process really stayed the same. It fell behind.
Leave us with a final thought here, and I know this may be outside your direct area, but the oil industry advocates say, well, look, Saudi Arabia and Russia don't apply all these conditions. Should Canada say, well, if you're not going to have these environmental safeguards, we're not going to bring in your oil anymore?
Well, that's an interesting approach. I mean, the fact is we've got where are we going to get the oil from? If we can't get pipelines built, even to get oil, never mind going west out to market, but if we can't bring it east to Ontario and Quebec, are we going to go oil-free in the eastern Canada? Doubt it.
Not last time I looked anyway.
Right.
Yeah, that's right. Mike, always great talking to you. Thanks very much.
Thanks for having me.
Mike Richmond has been our guest, co-chair of the Energy and Power Group at Macmillan and a former member of the National Energy Board.